that particular one? Yes, I was an advocate for the bills, protecting our immigrant communities across the state.
Well, this bill is another example of the problem that exists in the operation of our General Assembly, where we have a bill that does one thing, and in fact has broad or even unanimous support, and then is changed in a moment's notice, sometimes with just an hour's notice, and ends up being passed in one chamber and sent to the other chamber that same day, passed again with just an hour's notice. Basically what I view as a violation of the spirit, if not the letter, of the 3 readings rule in our state constitution.
That is State Representative Patrick Windhorst talking about the process by which a bill passed the Illinois General Assembly in fall veto session in October, just in hours, changing a bill that was originally focused on POW and MIA Recognition Day, prisoners of war and missing in action. It was a bill that passed unanimously in the House back in April. Never passed the Senate, but the Senate in October, and the last day of scheduled session, decided to gut and replace it and make it a migrant sanctuary enhancement bill. All right, welcome in. It's Illinois in Focus Daily. I'm Greg Bishop, and you can wake up with us each and every weekday morning for the latest here as we break things down for you in the land of Lincoln and how you are impacted as a taxpayer. So greatly appreciate you being here each and every weekday. And you can join the live chat where people are pretty conversational about the issues that are impacting the state of Illinois. And be sure to go to thecentersquare.com where you can sign up for the newsletter to get the latest headlines in your inbox, and be sure to share this up with your friends as well as we, again, break things down here in the land of Lincoln to get you what you need to know and on with your day. All right, so let's go ahead and get on into this. If you go to ilga.gov, you will find that you can kind of follow along with legislation. So go to the website, the Illinois General Assembly's website, go to Report and Inquiry, click Legislative Reports. There you will see Bills Pending Governor Action, and you click there. This is a report of all the bills pending governor action. So they've been sent to the governor, and he's got 21 bills on his desk. Now, Governor J.B. Pritzker does have a bill signing ceremony today that's going to take place this morning later on in Chicago, and deals with access to vaccines. So we'll hear a little bit about that. But as you can see, he's got a slew of other bills on his desk. One in particular that we're going to focus on today is the POW MIA Recognition Day. This is House Bill 1312, and it's nothing to do with prisoners of war or missing in action recognition. It was changed in the last day of fall veto session to be a bill enhancing migrant sanctuary policies. We talked about this previously when it passed, and you had House Speaker Chris Welch having a debate about the term illegal immigrant with State Representative C.D. Davidsmeyer. And again, you can go and find that story at thecentersquare.com. And even House Speaker Chris Welch breaking down what exactly this bill does on the House floor. And again, go to thecentersquare.com. You'll be able to see that with that article back in October and November when we
Not some people, all people should feel safe at our hospitals, which will be required to adopt safeguards concerning law enforcement's presence at healthcare facilities, at courthouses, where those ordered to appear in court for jury duty, a traffic ticket, or other businesses will be protected from extrajudicial abuse and detention. And on our college campuses and daycare centers, which will now adopt policies to protect students and children in their care, including protection against disclosing a family's real or perceived immigration status.
So that real or perceived immigration status line appears throughout the bill, impacting a variety of institutions, but it also allows for private right of action to be brought against individuals for assisting federal immigration enforcement officials or violating the Constitution. Governor J.B. Pritzker was asked before the holiday break if he's going to act upon this bill.
You're anxious? You need to know the answer right now? It has not.
Was not sent to his desk then.
Typically, it takes a little time to enroll these bills and have them delivered to me. There were a fair number of them actually from veto session, so no doubt they'll come soon. But we've had, I don't know, 1 or 2 holidays in between, and probably it'll be early December before, or late November probably, before I see some of them. That particular one? Oh, yes, I was an advocate for the bills, protecting our immigrant communities across the state.
So the governor anticipated he's going to sign this bill. And again, go to ilga.gov and look at the history of House Bill 1312, which, as we stated, started as a POW MIA Recognition Day to be observed in honor and remembrance of the men and women who, as POWs, have suffered captivity in foreign countries while in active service to the United States, and as MIAs have been recognized as missing in action in a time of war during period of hostilities. Provides the governor shall, in the governor's annual designation by official proclamation, that's some portion of the third Friday of September, be used for solemn contemplation and plight of the members of the United States Armed Forces who have been held prisoner of war and members of the United States Armed Forces who have been missing in action. So again, this was a measure filed by State Representative Maura Hirschauer initially, and then it's got some amendments that were provided. But you could see here, back when it was filed in January of 2025, earlier this year, you had a lot of co-sponsors sign on, right? Representative Dan Ugasti, a Republican, signed on to it. It was a bipartisan effort, and it passed unanimously back in April as the POW MIA recognition bill. But then you go further down, and you see that it got to the Senate eventually. The Senate had its first reading. The Senate had a second reading in May, but it never had a third reading before they adjourned at the end of May. But then come October, it was put on consideration for third reading. That then allowed for Senate President Don Harmon to file an amendment on the final day of scheduled session, October 30th. They heard about it, had a committee hearing about it. All within hours, it was brought up in the Senate and passed. So the Senate amended it with the migrant sanctuary status updates the last day of fall veto session, months after the House had passed a totally unrelated bill. So you can see the trajectory of this. And again, it gets to the House eventually, and the House passes it on October 31st on partisan votes. So you could see all of that passing 73 to 33 to suspend rules, partisan votes. Then they have the amendments that are passed, 75 to 32. And then you ultimately have the measure now on the governor's desk. So that's kind of the trajectory of this bill. For more of what exactly it does, again, here is Republican State Representative Patrick Windhorst, who opposed the measure on the House floor when it was brought up Halloween morning.
Well, the bill does several things. I think it's fair to characterize it as an expansion of the Trust Act in a lot of ways, just in general. But specifically, it creates civil liability for law enforcement officers, both federal and state, that are involved in activity that is found to be in violation of either the Constitution or state law as it relates to immigration enforcement. So in broad scope, it's an immigration related bill that expands the Trust Act.
So Windhorst, in the conversation I had with him yesterday, also delved into an amendment to the measure that does impact qualified immunity.
Yes. Initially, when the bill was filed and working its way through the General Assembly, there was a provision. Actually, it's called the Illinois Bivens Act, which references a type of federal lawsuit that exists for violation of constitutional rights. But it would say that any person, law enforcement or not, any person who while conducting civil immigration enforcement engages in a violation of either Illinois or the United States Constitution would be subject to civil penalties. Initially, when the bill was being heard in committee, we had a discussion and the speaker presented the bill. and noted that there was not a qualified immunity protection provision. That was later added with Amendment 5. Qualified immunity is a doctrine that says that an individual is not responsible or civilly liable for a violation of constitutional rights unless that constitutional right is, quote, clearly established, unquote, under the law, meaning there needed to be a prior court decision where the court says that this is a violation of constitutional rights. That way people are on notice. If they commit that action, they are subject to suit. So by including that, that does provide some protection to law enforcement that did not exist previously. To me, it wasn't enough to support the bill. I believe the bill goes too far, but it did provide protection that law enforcement was looking for.
And again, this is something that the representative says happened all within the span of a handful of hours, and he goes into some in-depth, explanation of, it's the issue of possible civil litigation against law enforcement that could be brought forward, but it's also the liability for several key institutions in the state of Illinois.
Yeah, this bill touches on a wide swath of our society, as you mentioned, dealing with higher ed, hospitals, and childcare specifically. And it's going to require these entities to have policies in place when they are engaging with law enforcement, in some cases beyond the immigration context. For instance, and the policy provisions related to the hospital, hospitals will be required to have a policy in place with how they will handle law enforcement on their premises, regardless of the purpose, immigration or not. In fact, so much so that a hospital is to contact their legal counsel when law enforcement is on the premises, which, as I'm sure you know and others who are hearing this know, law enforcement is often at hospitals completely unrelated to immigration. If they're bringing someone who has been involved in a criminal activity or an accident into the hospital for treatment or evaluation, or if a correctional officer has an inmate at a county jail who needs medical care, or they're brought to a hospital, all these things would trigger those notice requirements that are unrelated to immigration. And it does present penalties to hospitals, child care centers, and our colleges and universities if they do not either have the policies or abide by them, putting them at risk of those penalties that don't exist prior to this bill.
Again, State Representative Patrick Windhorst with that understanding of this particular measure, and he says that it's really not going to help the overall debate about federal immigration enforcement in the state of Illinois if the governor signs this expansion of the state's migrant sanctuary policies.
Well, I view this, as I said, as an expansion of the Trust Act, which I think is having a detrimental impact on immigration enforcement in our state. Of course, that's what the purpose of the law is in a lot of respects, not only the bill we're talking about, but also the Trust Act. And it's going to make for some of the issues we're seeing in the city of Chicago, where law enforcement isn't able to work with federal law enforcement, isn't able to work with local law enforcement in that immigration enforcement measures, where it's creating scenes that are chaotic and it's causing issues for those who are enforcing federal law. And I think this will cause an expansion of that, where our local law enforcement officers aren't able to help the federal officers. One other provision of this bill that it talks about any person designed toward federal immigration enforcement, but our U.S. Constitution, of course, has a supremacy clause, which will mean that this provision, as it relates to federal law enforcement, will quite possibly, in fact, likely be unconstitutional, meaning that the only law enforcement officers who are going to be subject to penalties under this will be our local and state law enforcement, which I feel creates another problem, and we're subjecting our law enforcement to these possible penalties at a time we're having a difficulty in recruiting law enforcement to work in our state. Now, as it relates to how the Trump administration and state government will interact, I think it's just going to be one more barrier for us to see the law enforced as it should be in an orderly way, and will potentially create other arguments to be made that actions taken by the federal government beyond the normal law enforcement actions would be constitutional or allowed by federal law.
Again, that's just a conversation about what kind of impacts this expansion of the state's migrant sanctuary policies will have on the overall debate of federal immigration enforcement in the state of Illinois and in the city of Chicago. But again, as we started off, this particular bill that's now on the governor's desk, and he can sign it at any time, it started off as a POW MIA Recognition Day law, passed unanimously out of the House in April. Had a chance to pass the Senate, never came up during the spring session. And then during veto session months later, on the final day of scheduled veto session, it's gutted and replaced from no longer being about honoring members of the military who are prisoners of war or missing in action. It then focuses on expanding the state's migrant sanctuary policies. Windhorst says this is yet another example of that gut and replace, he says, is a violation of the intent of the three readings rule in the Illinois Constitution for legislation.
Well, this bill is another example of the problem that exists in the operation of our General Assembly, where we have a bill that does one thing, in fact has broad or even unanimous support, and then is changed in a moment's notice, sometimes with just an hour's notice, and ends up being passed in one chamber and sent to the other chamber that same day, passed again with just an hour's notice. Basically what I view as a violation of the spirit, if not the letter, of the three readings rule in our state constitution. We see this often done with the budget, and unfortunately also large pieces of legislation that have broad impact like this bill does. It's a bad practice. That makes for bad law. And I think this is another example of a bad practice making bad law. This bill should have been one. We had 6 days in the veto session. If this is the legislation the majority wanted, we could have started with day one and worked its way through under what I would consider the appropriate or proper channels passing legislation. But instead, we have legislation that is major, broad, wide-ranging, passing with just a day's notice or sometimes less than that.
Again, just a handful of hours notice when it comes to this particular piece of legislation. So it's not the only one that's on the governor's desk that the title of it doesn't really match the contents of it. Again, if you look at the reports generated at Illinois General Assembly's website, ilga.gov, that was the Prisoners of War Missing in Action Recognition Day, House Bill 1312, that is now a migrant sanctuary enhancement bill. But another one that's got an interesting twist that's now on the governor's desk, it is the sanitary food preparation bill. All right, so 1950, Senate Bill 1950, sanitary food preparation. So it was filed by state senators, and amends the Food Preparation Act, provides that if food distribution facilities engaged in the collection, storage, packaging, or distribution of food to consumers, then that facility is subject to all provisions of the act. And it goes out and spells out more. That measure ultimately amended to be the medical aid in dying bill, or as others may call it, assisted suicide. So it's the End of Life Options for Terminally Ill Patients Act. This measure came up on the last day of veto session. And again, after gutting and replacing a measure about food safety, turns into an assisted medical aid in dying or assisted suicide bill that is on the governor's desk now, and he can enact it. And Right to Life, a organization that opposes abortion, they also oppose this legislation. They point to concerns that county coroners have raised about oversight and transparency when it comes to this issue, and they say that they're going to deliver petitions to the governor's desk. The governor has 30 days for when it was sent to him on November 25th to either sign or veto it. If he doesn't act, then it automatically becomes law. So we'll see exactly how this plays out. All right, it is Illinois in Focus Daily, each and every weekday morning, hoping to keep you informed and breaking things down so you can get on with your day here with the Center Square. All right, go to thecentersquare.com, get the headlines in your inbox, and like, subscribe, and hit that notification bell for Illinois in Focus Daily.